Hello, everybody. Thank you for joining us today for our second UN Permanent Forum site event. Today's topic is implementing the UN Declaration on the Rights of Indigenous Peoples in the US. We also want to make sure you all know we will be recording this meeting to share online for asynchronous viewing. And with all of that out of the way, I would like to welcome Sue Noe to give opening remarks and begin today's meeting.
Thank you, Kevin. Hello, everyone, and welcome to our site event today for the 21st session of the UN Permanent Forum on Indigenous Issues. As Kevin mentioned, our topic today is implementing the UN Declaration on the Rights of Indigenous Peoples in the United States. And we're very fortunate to have with us a fantastic panel of speakers with tremendous knowledge and experience who've analyzed and worked on issues related to the Declaration and its implementation at the tribal, national, and international levels. I'm Sue Noe. I'm a senior staff attorney at the Native American Rights Fund based in Boulder, Colorado. And the Native American Rights Fund is the oldest and largest nonprofit law firm in the United States representing the interests of Native American tribes. This event is brought to you today by the Implementation Project, which is a joint initiative that was formed in 2018 by the Native American Rights Fund and the University of Colorado Law School to advance education and advocacy regarding the UN Declaration on the Rights of Indigenous Peoples in the US. I'm the co-director of the Implementation Project, along with my colleague and friend, Professor Kristen Carpenter from the University of Colorado Law School. And Kristen is the Council Tree Professor of Law and the Director of the American Indian Law Program at the law school, as well as a former member of the UN Expert Mechanism on the Rights of Indigenous Peoples. I want to thank our panelists for generously taking time out of their schedules to be with us today. I also want to thank Professor Carpenter for all her hard work helping to organize this series of virtual events that we've been doing, as well as Kevin Miller, who's the American Indian Law Program Fellow at Colorado Law, Sarah Ortegon, who's our legal assistant at the Native American Rights Fund, and all the other folks on our teams who have helped make this event happen today. The UN Declaration on the Rights of Indigenous Peoples was adopted by the UN General Assembly in 2007 and recognizes Indigenous peoples' rights in many areas, including survival and self-determination, land and culture, political participation, and child welfare, as well as the safeguard of free, prior, and informed consent. Although it initially opposed the declaration, the US reversed its position in 2010 with President Obama's statement of US support for the declaration. But to date, we still have not seen much real progress toward implementation, as contrasted with what's happening in other countries such as Canada, Mexico, and New Zealand. When we speak of implementation, what we mean by that is the enactment of laws and policies that breathe life into the rights recognized in the Declaration. The Declaration is a standard-setting document, and implementation means seeing those standards actualized. Our project, the Implementation Project, has engaged in a number of activities to promote awareness about the Declaration and to help support implementation advocacy efforts, including producing publications, holding a series of in-person workshops for Indigenous peoples in different regions of the US, and virtual events such as this one. We have a website where we collect and make available information and examples related to implementation of the Declaration, and where you can find copies of our publications, news articles, information about upcoming events, and recordings of past events. The website is at un-declaration.narf.org. We have a publication that's forthcoming, a tribal guide to the UN, that may be of particular interest to viewers of this event today, and we'll be sure and let you all know once that's available. In collaboration with the University of California, Los Angeles School of Law, the Implementation Project has also developed a tribal implementation toolkit which provides examples and inspiration for tribes seeking to implement the Declaration in their own laws. And that's also available on the website. So we just returned from week 1 of the UN Permanent Forum in New York City, where tribal leaders and Indigenous peoples around the world were more engaged than ever in efforts to achieve the aims of the Declaration. This session's theme was Indigenous peoples, business autonomy, and the human rights principles of due diligence, including free, prior, and informed consent. And there was also a thematic dialogue on the International Decade of Indigenous Languages. US tribal leaders attending the forum made powerful interventions on implementing the Declaration, including use of the safeguard of free, prior, and informed consent in protecting tribal self-determination, participation in the International Decade of Indigenous Language to advance language rights, repatriation of sacred objects removed from tribes to international museums, and accounting for the harms of the boarding school era. Every one of these statements reference specific articles of the Declaration, showing its relevance and calls for the US and other countries to meet their human rights obligations to Indigenous peoples. In this panel, we have asked a group of distinguished experts for their perspectives on the purposes, challenges, and opportunities associated with implementing the Declaration in the US, whether through law reform, diplomacy, or other measures. President Walter Echohawk of the Pawnee Nation will present from the tribal leaders' perspective. Ambassador Keith Harper, a partner at Jenner & Block Law Firm, from his vantage point as a former US representative to the UN Human Rights Council and as an incoming member of the UN Permanent Forum on Indigenous Issues. And finally, Professor Angela Riley of UCLA Law School from her academic research and participation in negotiations at the World Intellectual Property Organization. These truly are the leaders in Indigenous peoples' human rights, particularly in the US, and we are grateful to have them with us. The speakers will present for 10 to 15 minutes each, and then we'll turn the floor over to Professor Carpenter for her reflections and remarks. Following that, we'll have time for some Q&A, as Kevin described. So with that, let me introduce our first panelist. Walter Echohawk is the president of the Pawnee Nation Business Council. He is a well-known Native American attorney, tribal judge, author, activist, and law professor. He has represented Indian tribes on important legal issues such as treaty rights, water rights, religious freedom, prisoners' rights, and repatriation rights. His career spans the pivotal years when Indian tribes reclaimed their land, sovereignty, and pride in a stride toward freedom. As a Native American rights attorney since 1973, President Echohawk worked at the epicenter of a great social movement alongside visionary tribal leaders, visited tribes in Indigenous lands throughout North America, and was instrumental in the passage of landmark laws, such as the Native American Graves Protection and Repatriation Act of 1990 and the American Indian Religious Freedom Act amendments of 1994. He litigated in many of the epic struggles and has written extensively about the rise of modern Indian nations as a Native American author with firsthand experience, such as his groundbreaking book, In the Courts of the Conqueror, The 10 Worst Indian Law Cases Ever Decided, which was published in 2010. He's also the author of In the Light of Justice, The Rise of Human Rights in Native America and the UN Declaration on the Rights of Indigenous Peoples, which was published in 2013, and which is the landmark text motivating advocacy for Indigenous peoples' human rights and implementation of the Declaration in the US. So I turn it over to you, President Echohawk.
Thank you, Sue, and good afternoon to everyone. I'm very honored and pleased to be here, and I'm appearing today basically as a scholar and practitioner of federal Indian law here in the United States. Federal Indian law is the current legal framework for defining Indigenous rights and relationships and responsibilities. And this is a very exciting time, I think, in the history of federal Indian law. For the times, they are a changing. And thanks to this UN Declaration on the Rights of Indigenous Peoples, we stand at the very, I think, inception of a brand new era in federal Indian law, and that is the human rights era. Just briefly, here in the United States, like many nations, our democracy is heir to a legacy of conquest and colonialism that was every bit as strident as any colonization process during the era of colonialism, such that by the year 1900, there were only 250,000 Native Americans left alive, which was essentially about a 5% survival rate of their encounter with conquest and colonialism as the United States expanded across the country and built the modern democracy that we see today. And many of the much of that legacy is still visibly seen in the legal system. It's etched into the doctrines of the early law of colonialism by Supreme Court decisions that still remain the law of the land today, that have never been reversed and are still relied upon to decide modern cases. And I know that when I was young, way back in 1970, law student, the challenge of our generation back then was to work to implement President Nixon's 1970 Indian self-determination policy. And that work in the tribal sovereignty movement took 2 generations, really, to implement this self-determination policy across the United States. And during that time, we saw great nation-building strides take place and witnessed the rise of our modern Indian nations that we do see here in the United States. And the legal strategy back then in those generations essentially was to use our existing legal system as we found it, federal Indian law, with both its protective features from the inherent doctrine of tribal sovereignty and the protectorate principles of Worcester v. Georgia, together with the dark side of it, the nefarious legal doctrines from the early law of colonialism. And our strategy was simply to try to coax the courts and the Congress to use the protective features of federal Indian law for legislation and litigation purposes. And then we just simply lived with the dark side of federal Indian law. And so tried to cope with those nefarious legal principles and never mounted a frontal assault to try to overturn or reform the dark side of federal Indian law. So this has been an imperfect legal framework for Native people here in the United States. And there is an axiom here that a race of people can only go or advance so far in their aspirations under an unjust legal framework. And to advance much further, I think, in our aspirations, we need to finally turn and confront this dark side of federal Indian law and try to reform it and replace these outmoded doctrines of colonialism in the law with human rights principles that come to us from this UN declaration. shows us the way. It shows all nations how to rid themselves of the lingering ill effects of legacies of histories of conquest and colonialism, including the dark side of federal Indian law in the United States. And so I think today's challenge here in the United States is to actually work to implement the human rights standards of the UN Declaration into US domestic law and policy. And I know that in North America, this is an exciting time, and we can look up to Canada as leading the way to entering into the human rights era. In 2021, last summer, the Parliament there passed a national law embracing the Declaration and requiring Canada to ensure that its laws conform with the Declaration and to create a national plan of action to do so. That followed on British Columbia, its legislation in 2019 to align the laws of British Columbia with the UN Declaration standards for that province. And just recently, a couple of weeks ago, British Columbia came out with its action plan to align the laws of that province with the Declaration. So Canada, thanks to the advocacy of the First Nations, is well on its way to entering into this human rights era of Indigenous rights here in North America. By contrast, the United States lags behind. We are not the leading democracy when it comes to Indigenous rights, it seems. The Obama administration endorsed it in 2010, but there's been very little movement ever since then. We have no national plan here in the US to implement the Declaration. And the Biden administration appears strangely silent on the implementation effort here. On the one hand, we see it pouring billions of dollars into Ukraine to protect the sovereignty and human rights from the Russia's savage war of conquest there. But in our own backyard, we see no movement to implement this declaration here in the United States in the face of growing calls that we see by tribal nations here in the United States for the Biden administration to begin developing a national plan to implement the declaration into US law and policy. We have here in the United States this National Implementation Project founded by CU Law and the Native American Rights Fund. The National Congress of American Indians passed one of many resolutions, most recently October of 2021, calling on the United States to develop a national plan to implement the Declaration. Here in Oklahoma, the Intertribal Council of the 5 Civilized Tribes passed a resolution making the same request. Please, let's get a national plan in place. That follows on the Muskogee Creek Nation and many other tribes endorsing the Declaration into tribal law, including the Seminole Nation endorsement, the Cherokee Nation endorsement, Gila River endorsement, the Navajo Nation's Human Rights Commission, and others, including my own Pawnee Nation here. We enacted a government-to-government consultation statute that, among other things, incorporated the free, prior, and informed consent standard of the Declaration when consulting with our nation on vital tribal interests, laying out our standard for government consultation. And we have a more robust bill that is pending within the Pawnee Nation to carry forward and make our request to the government. to implement this declaration into U.S. law and policy. Thus far, to my knowledge, these tribal efforts and requests have fallen on deaf ears. And so I think it's the challenge of our nation in this generation to work together to coax the United States into taking some concrete steps here in its own country to implement the standards into U.S. law and policy. Thank you. Appreciate this opportunity, and that concludes my remarks.
Thank you, President Echo Hawk, for those remarks. It's very interesting to hear about the experiences of the Pawnee Nation and also your long history of experience as an advocate on behalf of tribal people in the U.S. I also wanted to mention that Caleb Ben from the Assembly of First Nations of Canada in the chat has included a link to the AFN website that includes resources on implementing the declaration in Canada. And so want to make sure that people see that message in the chat and have access to that website. So thank you for sharing that as well. So now I'm going to introduce our second panelist. Ambassador Keith M. Harper is a partner at Jenner & Block, where he is chair of the Native American practice and co-chair of the Human Rights and Global Strategy practice. During the 2021 to 2022 academic year, Ambassador Harper is also simultaneously a senior fellow at Brown University Watson School for International and Public Affairs. From 2014 to 2017, he served as United States Ambassador and Permanent Representative to the UN Human Rights Council in Geneva, Switzerland. From 2010 to 2014, Ambassador Harper served as Commissioner on the President's Commission on White House Fellows. In April 2022, Ambassador Harper was elected to a 3-year term as an independent expert to the Permanent Forum on Indigenous Issues, and his tenure will commence on January 1, 2023. He is a citizen of the Cherokee Nation. So I turn it over to you, Ambassador Harper.
Thanks, Sue, for that introduction, and thanks for the invitation to present some remarks today and on this really critical topic. I thought I would sort of have 3 categories of observations, for lack of a better term. The first is that I think the proper starting point for a discussion, or one of the proper starting points for this conversation, is to discuss what the Declaration actually represents. Of course, under international law, it is a non-binding instrument as opposed to, say, treaties. The distinction is often put in terms of those things which are hard law and those things that are soft law. The U.S. position, of course, is that this instrument is non-binding and aspirational in nature. But in a lot of ways, I think this distinction between hard law and soft law is a bit of a distinction without a difference. Treaties in and of themselves are under U.S. law not self-executing. So they're law under international law, but they're not law in domestic law. And so there has to be some mechanism to domesticate them. And the fact that they're aspirational rather than binding, I don't think should be of much import, because you still should have a plan to reach the aspiration. So that to me is a bit of a non sequitur when people identify it as aspirational, and somehow that should have a difference. So that all brings me to the statement, and I think my colleague Walter Echohawk, fellow panelists, and who I worked with at the Native American Rights Fund for many years, basically brings it to this point, that what the Declaration's real utility is, at least presently, unless it's been domesticated in U.S. law, is not so much a legal instrument, but a political instrument, a political tool. And this understanding is important because it frames our ability, our comprehension as how the Declaration can be used productively and conversely misused counterproductively. It should be used to advocate policies that here in the US aid Indian tribes and tribal communities in achieving their objectives. One way to do that, again, as Walter alluded to, is to more globally adopt it under US law. It sounds like Canada has done something of that nature. It also can be used on an individual basis to cite the provisions in a political context to advocate for various policies that might advance the rights of Indigenous groups, Indian tribes, and tribal communities in the United States. So what does that look like? So I thought what I would do is take a few examples from the Declaration, a handful, to talk about how do you use it as a tool for political advocacy. So if we were arguing, for example, for a statute to get enacted that gave greater self-governance or promulgation of a regulation that gave greater self-governance to tribal governments, then one, of course, could cite numerous provisions of the Declaration. Among those, you could cite Article 3, for example, which provides Indigenous peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. So that's a clear statement of self-determination. If a policy, a statute, a regulation is that a tribe is pursuing, or the tribes more sort of writ large are pursuing, addresses issues of giving them establishing greater autonomy, rights to decide policies that impact their communities, then this, among other provisions, is key. Obviously, the numerous times the Declaration uses the term free, prior, and informed consent is also a basis to say that, especially in the decision-making capacity, tribes should be the drivers of their own destiny, and that statutes and regulations, federal statutes and regulations that advance those interests would be consistent with and are really called for by the Declaration itself. If advocating for an Indian tribe on enhanced decision-making, you have, among others, Article 32 of the Declaration, which provides Indigenous peoples have the right to determine and develop priorities and strategies for the development and use of their lands and territories and other resources. And I don't think this is academic. These provisions and many of the provisions are relevant to most, if not all, of the priorities that tribes are seeking. As we know, just a few years ago, we had the issues up in Standing Rock that really had to do with the use of lands and the potential impact on resources such as water on the Standing Rock Indian community. And look, if the provisions of the Declaration were followed, it was clear in that instance that there was not free, prior, and informed consent. Now, I don't know presently whether I think it's unlikely that because it's not been codified into U.S. law that is enforceable. There's other provisions that are potentially legally and were legally enforced through litigation, but that concept of free, prior, informed consent can be a political tool, whether in dealing with federal decision makers, whether dealing with Congress, or whether dealing with the advocacy for taking specific action in places like Standing Rock. And of course, this issue arises time and time again throughout the country because there is an impact on decisions on tribal communities, their lands, and their resources. Another example is the provisions of the Declaration that deal with the autonomy of tribes in deciding what to do with their children. Right now, we're in the throes of litigation that has reached the Supreme Court in the Rakim case. And though I don't think it can be cited effectively in that litigation, to the extent that Congress can address any infirmities that are determined by Burkine. Again, let me be very clear. I think the Indian Child Welfare Act is very much a constitutional statute in every respect. But if there is any challenge with this conservative court, then to the extent that it can be addressed by statute, these provisions of the Declaration, I think, are just another political tool in that ultimate conversation. The third point is that we should talk about why we should invest in the Declaration. And I think that from this perspective, and this sort of looking broadly at human rights more generally, I think there are a number of things that come to mind as to why the Declaration can be of such import. The first thing, of course, is it's a norm-setting exercise. It establishes the measuring stick. It provides states with specific expectations of how we should measure their conduct. Key to it's been true time and time again that key to progress in advancing any rights has been this kind of establishment of the proper metric. What is required when one says they are in compliance with human rights norms addressing Indigenous peoples? And again, I do want to mention that there's a lot made of it being a declaration rather than a treaty. But of course, one of the critical human rights instruments that's widely considered central to human rights law is the Universal Declaration of Human Rights. And it's largely considered customary international law at this point, and is regularly cited by the Human Rights Council. I also mentioned the expectations issue. States have to understand what is required of them, and then and how they can say they are in compliance. And this is another critical aspect of having this norm setting. And finally, as I mentioned earlier, it's this political tool, and ultimately it can potentially be used as a legal tool if it is domesticated, as has happened in some places, but not the United States. One thing I want to put on the table is that as we think about how to domesticate and utilize the Declaration, in my estimation and in my experience, it is critically important to have a senior level federal official who is in charge of implementing the Declaration. That their success is measured in part by how well they have instituted the Declaration's terms under domestic law. In how many situations the United States is in compliance with the principles and norms set forth in the Declaration, and then have the ability to measure that success with the measuring stick created through the Declaration. And finally, I would just say, I very much appreciate the collaboration with NARF and the University of Colorado Law School, in part because in advancing rights, whatever they are, what we know is that success is not preordained. That success takes hard work by many people over many generations. And Walter alluded to this as well when he started practicing in the 70s. This concept of sovereignty was there, but it took a lot of hard work, litigation, advocacy in congressional halls, advocacy with the departments of Interior and others that are advancing tribal policies, and over time, with incredibly diligent work from institutions like the Native American Rights Fund and the National Congress of American Indians and tribes around the country, we advanced rights of tribes. Whether that was the Indian Child Welfare Act, all the way to, in 2013, the inclusion of a provision to give tribes jurisdiction over non-Indians in the reauthorization of the Violence Against Women Act. And so this success doesn't happen without this kind of advocacy. This success doesn't happen without pursuing it and people being diligent about ensuring that its implementation is made year after year. And so I commend the project. I think it's critical, and I think it will have a measurable impact in the real world. And of course, that's important because that'll impact the lives of tribal communities all over this country. So with that, I'm going to close, and I look forward to further discussion.
Thank you, Ambassador Harper. Thank you for those remarks and for your kind words and inspiring words about the impact that the project can have and hopes to have in this struggle that we're involved in. I wanted to go back to your idea about the senior level federal official who would be charged with advancing U.S. compliance, advancing and monitoring U.S. compliance with the declaration provisions. And President Echo Hawk mentioned the NCAI resolution and the 5 tribes of Oklahoma resolutions calling on the Biden administration to develop a national action plan for implementation of the declaration. And I'm just wondering how likely it is that you think it would be possible to establish something like that, either the senior level federal official, the National Action Plan, and what's the best approach for those of us who would like to see those things happen to advocate for that?
Yes, I think it could happen. I think there's a couple of different ways that it could happen. I've advocated previously for the establishment of a special envoy for Indigenous peoples issues at the State Department. I think that could have a variety of virtues associated with it. During my tenure at State, there was the establishment of the special envoy for LGBTI rights. And so that individual was at every conversation within the international organizations or bilateral engagement that might give rise to questions of LGBTI rights. And so it prioritized that issue. It sent a message to the world that the United States believes those rights are critical, and advancing those rights are critical. And so it has a galvanizing impact as well. And so I think that the establishment of the special envoy has a lot of virtues. I don't think it necessarily, and I just put that out there because I want to contradistinguish that from what I'm talking about here, because I think this should probably be within a domestic agency, not a foreign policy agency, because you're talking about impacting U.S. law and policy. And so maybe at the Department of Interior or something of that nature, where you have a senior individual who has the weight of the federal government behind it, and their task is to actually ensure the implementation of the declaration, meaning change laws that are then more consistent with the principles set forth in the declaration. And so I think that's possible. I think that the way you get there, though, is it needs to be a priority for tribal governments. If tribal governments make it a priority, particularly with this administration writ large, I think there will be enough political energy to do it. If there's not that kind of advocacy and call for it, then I just don't think that there's too many other things that are critical to tribes that are on the agenda of the folks at the Interior Department, for example, and the Biden administration. And so I think it's going to take that kind of advocacy from tribal leadership, because that's what the administration is responsive to and should be responsive to.
Great, thank you. And I'm really interested in how international law and national law and tribal law, how these all influence one another, and how advocacy in one area can help with advocacy in another area. And so I don't know if Professor Riley or perhaps Professor Carpenter might speak more to that in their remarks later, but thank you, Ambassador Harper. And now I'm going to introduce our third speaker, Professor Angela Riley. Angela R. Riley is a citizen Potawatomi Nation tribal member. She's professor of law at UCLA School of Law and director of UCLA's Native Nation UCLA's Native Nations Law and Policy Center. She directs the JD-MA Joint Degree Program in Law and American Indian Studies and has chaired the UCLA Campus Repatriation Committee for over a decade. Professor Riley's research focuses on Indigenous peoples' rights with a particular emphasis on cultural property and Native governance. Her work has been published in the nation's most elite legal journals, including the Yale Law Journal, Stanford Law Review, Columbia Law Review, and numerous others. She received her undergraduate degree at the University of Oklahoma and her law degree from Harvard Law School. In 2003, she was appointed to her tribe's Supreme Court, becoming the first woman and youngest justice of the Supreme Court of the Citizen Potawatomi Nation of Oklahoma. In 2010 and again in 2016, she was elected by her tribe's General Council as Chief Justice. She previously served as co-chair for the United Nations Indigenous Peoples Partnership Policy Board and has worked in a judicial capacity for the Morongo Band of Mission Indians, the Rincon Band of Los Sueños Indians, and the Pokagon Band of Potawatomi Indians. Professor Riley is a member of the American Law Institute, and a co-editor of the Cohen's Handbook on Federal Indian Law. She taught as the Oneida Indian Nation visiting professor of law at Harvard Law School in fall 2015 and co-teaches the nation building course at the Harvard Kennedy School of Government. So I turn it over to you, Professor Riley.
So I'll just continue. The work that I'm referencing by 3 different publications. One is, as I mentioned, the Indigenous Peoples and the Jurisgenerative Law and Human Rights. The second one is an article that will be coming out later this year in the Michigan Law Review called "The Ascension of Indigenous Cultural Property Law," which is a broad and deep application of the cultural property law of Indigenous peoples, is particularly the 574 federally recognized tribes within the United States. And then the Tribal Implementation Toolkit, which was a joint production of the Native American Rights Fund, the University of Colorado School of Law, University of Los Angeles, UCLA School of Law, that again talk about gives sort of a roadmap to implementation for tribes. What I want to talk about is the implementation of the declaration into tribal. And just say a few words about why I'm focusing on tribal law. I don't need to go into much about why tribal law is important. I'm sure most of you on the Zoom are very, very familiar. But my focus on tribal law has been particularly in the property and intellectual property space, has been an effort to try to really get my mind around, as a scholar and an Indigenous rights advocate, for what tribes are actually doing in this area, what tribes actually want. I found my own work working with aspects of intellectual property, in particular in the United States, applied in the Indigenous context. There's a clear understanding at this point that the Western model of IP, which includes copyright, patent, and trademark, among others, don't adequately capture Indigenous desires and goals with regard to the end of cultural property. But the question then comes up of what is it that tribes actually do want? Do those protections look like, or should they like? And to examine that, really turn to tribal law to see what tribes are doing in this area. Are they enacting legislation? Do they have protections in their law? What do those protections look like? How do they differ from Western legal systems, if at all? How do they capture tribal worldviews? How do they advance tribal sovereignty and determination, among others? What I found in my research is that it's an incredibly fascinating thing and body of law that is out there. Some of it is emerging, and tribes are doing all kinds of amazing innovation in this area. And so will be captured in the article that's for this year, the Ascension piece, and I'd be happy to talk more about it if people are interested. So what this focus has been, and Sue brought up this question, is how are all of these things related? How is tribal law acting with federal or national law and with international? And the juris generis that Professor Carpenter and I wrote together focuses on what we call multiple site engagement. which is a term that we borrowed from the law professor Judith Resnick. The idea essentially here is that what we observed in the world is that all of law at all of these levels are influencing one another. So just to give you an example, in the United States, for example, after passage of NAGPRA, the Native American Graves Protection and Repatriation Act, one of the things that we in tribal cultural laws are there's a great emphasis on burial sites and ancestors and remains and items surrounding that cultural patrimony. In many cases, uses the language of NAGPRA, and in some cases, actually explicitly references statute. So there you see federal or national law be animated or given a space in tribal law. That's just one example. But what we're also seeing is, for example, tribes actually citing to the UN Declaration on the Rights of Peoples in their own tribal, and some tribes are expressly adopting the Declaration. And then come around again, you see in the international sphere various efforts at the UN level to really give voice to Indigenous peoples by looking at tribal. What is it that tribes are, or what are Indigenous peoples doing on law on the ground? So what we see here is a loop. And it's not just going in a circle, but it's coming back and forth in a dynamic relationship. And that's what we call the multiple side engagement. And we're seeing more and more of this. This goes to really write the points that were made by my co-list, President and Ambassador Harper, to really understand that regardless of how the U.S., for example, is acting with regard to concrete implementation of the Declaration, consistent application of and advancement of the rights Declaration, both expressly and implicitly, either in tribal law or in other fora, are actually advancing the ball. And it's important and critical for us to understand that and to understand how it's, which is part of what my research does. Are actually implementing the Declaration in tribal law concretely, but also interacting with the UN system in a variety of ways. This is just a snapshot of a few examples. Many of these are contained in the toolkit if you want to get a sort of more concretely how to doing this. We see express reference to the Declaration in places like with the Navajo Nation Human Rights Commission. Several tribes have actually passed resolutions to expressly adopt the Declaration in whole or part. You have some example slide. The Muskogee Nation actually translated the Declaration into Muskogee Creek language and gave it its own sort of life within Muskogee Creek law. I think, as far as I know, it's the only tribe to have done that. Certainly was the first. And then you have other efforts and participation in UN system. So, engagement with the expert mechanism, engagement with the Indigenous, the Decade of Indigenous Languages. So these are just some examples. This kind of I know running out of time, and it just sort of, this is a piece, an actual quote, the Navajo Nation Human Rights Commission. They see references as the Declaration and its embodiment in Navajo law. And similarly, the Muskogee Creek Nation District comments on the Declaration. Turning to the multiple side engagement, one place I wanted to just point this out, that I've been working with Sue Noe and other people at NARF on the World Intellectual Property Organization's efforts within the United Nations to advance protection for Indigenous traditional knowledge, sort of broadly conceived. And part of those conversations have been what tribes want, what do Indigenous people want, what does that protection look like, how might life in an international instrument that could actually advance those rights on the world, in the United States and beyond. So again, there you're seeing multi-side engagement and what we do when we're at WIPO and trying to work on this on these instruments is try to reflect what Indigenous peoples want. That's difficult because who speak for all Indigenous peoples, and no one. I don't even speak for my own tribe on this specific matter. But what I can do is share the research that I've done and give a scholarly perspective of what I see tribing and what I hear Indigenous people in the world wanting and desiring with regard to protection of their cultural property, genetic resources, traditional knowledge, and beyond. What this might raise for you is an obvious question. What is the role of the United States of this? Where is the U.S.? And I think as President Echo pointed out, the United States has left behind, and the United States has been very reluctant to sort of create any kind of national legislation that concretely embodies the decision. Other countries like Canada and New Zealand have taken more progressive, proactive steps in this regard. So we do see some resistance in the U.S. That said, we've also seen some important change. I mean, certainly the United States was the last country in the world to endorse the Declaration in 2000, but we did endorse the Declaration in the Obama administration. We didn't see a lot of movement in the subsequent presidential administration. But now, of course, we have first Indigenous Secretary of the Interior ever in the history of the States, and we're hearing more discussion, things like free, prior, and informed consent, terms from the Declaration that are appearing in the national dialogue around Indigenous rights, even if they're not expressly referencing the Declaration. It's part of the conversation, and that is. We're seeing more citations to Indigenous and international law advocacy in the federal court, even if we're not necessarily seeing a lot of it appear in federal court opinions, although that has happened as well. So all of this is to say that this is before us, our ancestors and our mentors and leaders, many of whom are on Zoom, have laid the groundwork for us, and now we're just trying to advance to the next level. And so I do see that the resistance is real, but I don't feel insurmountable. I will just close with Jaginaginan. This is my relations to all my relatives in Potawatomi. This is a picture of Saddle Mountain, which is right behind the farm where I was raised at the Iowa-Comanche county line. And with that, I'll close. Hopefully I didn't drive you all crazy too terrible, and turn it back over to.
Thank you, Professor Riley. And yeah, I apologize for that technical difficulty with the audio there, but still a wonderful presentation. I really appreciate all that information. In talking about the World Intellectual Property Organization negotiations and the US position there, I'm thinking about the comment that Ambassador Harper made earlier about the idea of creating a special envoy for Indigenous peoples' issues within the State Department. And because we do have that experience with the negotiations and the US positions at the World Intellectual Property Organization, which don't seem to really be reflecting so much the provisions of the Declaration there. So, well, thank you to all our presenters for those presentations. And now I'd like to turn the floor over to Professor Carpenter for her reflections and remarks. Professor Carpenter.
Thank you, Sue. I think first I'll do a sound check and ask if I'm accelerated or echoing. Okay, great. Well, thanks to the presenters and our really robust audience. We had 100 people on at one point, and given that there are probably 10 competing side events at this exact time, I think this is a really wonderful show of interest in the topic. And also by way of reflection, I think the fact that we have our leading Indigenous diplomats, leading tribal leaders, and leading academics, as well as the Native American Rights Fund, deeply engaged in this work of implementation, gives some substance to Angela's hope that this isn't an insurmountable set of obstacles, that hopefully we will follow our friends in Canada and other countries toward making this declaration more real, as Ambassador Harper said, in the lives of Indigenous peoples, because however we get there, that's what we're trying to do, right? We've recognized as a world community of the Indigenous peoples that Indigenous peoples are entitled to universal human rights and to realizing them in their own contexts. And some of the challenges we face in the United States include that the universal right to religion, right, recognized under the Universal Declaration of Human Rights, the International Covenant of Civil and Political Rights, it's not meaningfully enjoyed by American Indian tribes in the United States when the federal government can destroy sacred sites and our Supreme Court holds that's legal under the First Amendment. So we have really serious human rights challenges in the United States and real reasons to do this work, I think, from a human rights perspective. And I appreciated that President Echo Hawk, through his research, really underscored more broadly than I just did, the need for the declaration, the ongoing colonial legacies that make federal Indian law not sufficient to protect the rights of tribes. And I think sometimes those of us who have been practicing under this body of law for so long, even we become really bogged down and it's hard to see a set of alternatives. And one thing that's amazing about being here at the United Nations and seeing hundreds of Indigenous peoples working around the world on similar issues is that there's a lot of solidarity and energy and a way to look at things differently. And I appreciated Ambassador Harper with his incredible experience as a diplomat, and to have a tribal member who represented the United States to the Human Rights Council and who will be on the permanent forum is just such an opportunity for us to have closer relationships, I think, with the United States and push this work forward. But I appreciated from his perspective how he outlined the opportunities for advancing what President Echo Hawk powerfully described as a set of needs. We have to do this work, and there are opportunities for doing that, as Ambassador Harper said, through diplomacy, through policy work, and possibly through making this declaration legislatively implemented as a matter of law. And Keith, I so much appreciated your point that in the United States, there's almost this, I don't know, sense of repose about the fact that this is a declaration and not a treaty, because in the United States, we have such a hurdle to implement treaties in the first place that we're kind of almost in the same boat when it comes to instrumentalizing or operationalizing the declaration. We have to do it through domestic implementation. This isn't a country where an international treaty automatically becomes enforceable in domestic law anyway. So we might as well do it with respect to the declaration in the way that we're doing in some other settings. And then Professor Riley, I appreciated how you followed from the need and the opportunities to examples of this really happening on the ground. And this isn't an aspirational movement. Tribes themselves have decided to make it real. And I think one of the reasons we decided during the Trump administration not to be partisan about it, but the implementation project decided to look at what was happening in tribal communities because we didn't see a lot of opportunity for working with the federal government during that time. And when we looked to tribal communities, they were doing amazing work. You mentioned the Muskogee Creek Nation adopting the declaration as a matter of their own domestic law. So it's no longer right to say, at least generally, that the declaration is not binding in the United States, because it is actually binding in some places. It's binding in the Muskogee Creek Nation. It may become binding in other tribal jurisdictions. And remember that the Muskogee Creek Nation just won the McGirt case. I mean, the jurisdiction of tribal nations under their treaties is in fact being reaffirmed by the Supreme Court. And so that's an incredible opportunity actually to realize the aims of the declaration as the United States and others have already promised. And I guess with your indulgence, I'll just say two more things. We could, in addition to the points Professor Riley made about tribal governments, observe a few they're small, but they're important examples of implementation. There are several agencies, the Advisory Council on Historic Preservation, and I think there's a representative here, the Environmental Protection Agency. There are some agencies that have explicit guidance on the declaration in their internal policy. And I had a recent conversation with Judge William Canby, and he really underscored that as an important way to advance implementation, because there's so much deference accorded to agencies by the federal courts. If the agencies themselves, with their expertise over certain realms, advance the declaration, then the courts may well defer to those internal judgments. So that's, one avenue. We've also seen there's just one, to my knowledge, but the federal district court in New Mexico cited the declaration, albeit in a footnote, in an early stage of the Jemez Pueblos litigation around Aboriginal title. And I think this goes to a point a number of us have made about the use of the declaration as an interpretive device in current litigation over constitutional rights or treaty rights and so on. And even though it's true, the declaration is not yet a federal statute, there's nothing that would stop a court from referencing the declaration when it's interpreting current standards under the First Amendment for religion, or interpreting current standards under the Fifth Amendment, like an Aboriginal title. So I think that's perhaps another venue. And then as Ambassador Harper and Professor Riley and Sunoe and President Akok all mentioned, I think we're all hoping to work with this administration, and it is a challenge. I think it's a challenge for them, it's a challenge for us, but the administration is currently staffed with people we all know and love and can talk to pretty candidly. So I hope that we can work toward a national action plan, a high-level official, both in the external and internal work, in agency policy and compliance, all towards making this real, using both, all branches of the government, is I guess what I'm supposed to be, what I'm saying, judicial, litigation, legislative work, and agency policy. And I'll conclude my remarks by saying, we're doing a deep dive looking into what's happening in the United States, finding the seeds from Indigenous people's own communities, to work on a bottom-up movement. But I think it's also critically important, as several have said, that we look around the world to see what's happening in other countries. As Professor Riley mentioned, New Zealand has a national action plan. I worked on that when I was on the expert mechanism. Paraguay actually just this week announced a national action plan to implement the declaration. Mexico City adopted the declaration as a matter of its own constitution. And we know that Canada adopted national legislation to bring its internal law into alignment with the declaration. So I think, especially when it's our close neighbors, and we remind folks in the United States that Canada, right, our close neighbor, maybe friendly rival, is getting to the punch, getting to human rights more quickly than we are in the United States. Shouldn't that inspire us perhaps to get on board? And Caleb, I don't even know how to pronounce your last name, with apologies, but and Sue, with deference to you, would it be okay if we asked AFN just maybe provide a few words of reflection? And I don't mean to put you on the spot, so feel free to decline, but I think this audience might love to hear just a couple of minutes about the Canadian experience.
I think that'd be wonderful.
One, can people hear me? Yes? Okay, my name is Caleb Bain. I'm at Dene and Daneza. I come from Treaty 8, the BC-Yukon border. But I'm coming to you today from unceded and occupied Nuu-chah-nulth territory on what they call Vancouver Island. I'm the Director of Rights for the Assembly of First Nations. I was the Legal Policy Advisor in National Chief Bell Garden. Before that, I was the Special Advisor on Water to the Assembly of First Nations. A law kid, for sure. I'll be brief. One, it's an honor to be here. Masi Cho to Sue and Kristen, Keith, Angela. I'm trying to look for Walter. Masi Cho for your words. I put a lot in the chat, but a couple points I wanted to make. One, Sue, I think we've discussed this briefly with my boss's boss's boss. It would be really useful to have a cross-border discourse, in particular relative to Article 36 and the J Treaty Tribal Alliance that's looking at implementing the UN Declaration. Because of the J Treaty in Article 36, there's actually a rich potential to utilize what's happening in Canada to catalyze perhaps some advocacy on the other side of the medicine line, south of the border. For context, in Canada, our law works a bit different. We were successful 155 years of advocacy, essentially, in getting this law passed on June 21st, the solstice last year. It has three operative components, and I'll just kind of address some of the points made by the panelists as I describe the law. So the law works, one, the National Action Plan is going to be tabled on June 21st, 2023. The entire law has provisions of consultation and collaboration, which is a direct link to Section 35 of our Constitution, which is the basis of contemporary Indigenous, Aboriginal laws, they call it, Indigenous law, colonial Indigenous law in this country. I'm a graduate of UVic Law. My Auntie Val runs the UVic Indigenous Law Research Unit. My buddy John Boros and I and a bunch of others were building that program when I was back in law school. And the trajectory of Indigenous laws and legal orders being formally recognized and manifesting in Canada is evolving rapidly, but I know that it's distinct from sort of the tribal approach that you guys have, but the process is evolving fairly quickly, particularly in BC. BC is the most advanced at the provincial level, so that'd be a corollary to your state situation, I gather. At the federal level, the way it's working now is the Ministry of Justice. So to your point, Keith, I concur with the analysis, outwardly facing. Internally, it's the Ministry of Justice, as I put in the chat, that runs implementation procedures here in Canada. And that was intentional. There was actually an internal fight in the government about which ministry would be the lead. It makes sense that it would be the Justice and Attorney General. That's the linkage point, because laws and policies naturally fall there anyways. Sorry, I'm just trying to get my notes here. For Mr. Echohawk, in our case, the preamble, which of course is not formal law, but is persuasive in interpretation, explicitly rejects the doctrines of discovery and terra nullius. It is the first federal law to ever do so. I think it's the first law in a Western democracy to ever explicitly reject the doctrines of terra nullius and discovery. And you will note the recent advocacy we've done with the papacy. With the recent mission to the Pope, to the Vatican, and we expect formal repudiation of those doctrines shortly. So that might be an advocacy point for you guys insofar as your historic case law relies upon those doctrines. It's intrinsically wound in. And then, Angela, I like the analysis of multiple site engagement. What we have here is an annual reporting process, again, in consultation and collaboration with Indigenous peoples. One of the comments in the chat talked about the need for a national consortium of advocates. In Canada, we have 3 national Indigenous organizations, the Assembly of First Nations, advocating on behalf of over 1 million First Nations people, but there's also the Métis National Council and Inuit Tarpart Kanatami. So we had a fairly robust group, but there's a bunch of other organizations, treaty groups, like I'm Treaty 8 both sides. So Treaty 8 is an advocacy organization. There's various sort of like regional structures, you know, the Haudenosaunee, et cetera. There's a lot of Anishinaabe Nation, et cetera. There's all kinds of groups. So I think to end, recognizing and taking time, one, I recommend Sue and Kristen and to the panelists as well, that we have a more robust discourse on cross-border issues. The J Treaty Border Alliance and the application of Article 36 pursuant to the existing law in Canada would be a useful linkage point to tribal law on the other side of the border. And I think that overall, we're looking at the alignment of laws. So Section 5, there's a link in the chat. Section 5, which is the most powerful and hard-fought provision that we got in this work, requires Canada to align laws and policies, in our view, with the UN Declaration. And that, Keith, is the leverage point that alters significantly litigation tactics. It alters analytical processes. It provides a rich and robust foundation for a more evolved interface with colonial governments. And you'll note that National Chiefs comments at the Permanent Forum have often remarked on the capacity of the UN Declaration to unlock economic potential and address historic brutality and genocide. And it's that sort of two-pronged, if you will, interface analysis that has yielded significant dividends, and thus the progress we see in this country. But it's hard fought and it's evolving. So I encourage you guys to look to us to the extent that you can, and we'll look to you. Yes, if anyone wants to get a hold of me, I'm the Director of Rights at the Assembly of First Nation. You can find me on the AFN website. It's not difficult. So I'd be happy to chat with anybody or just direct message me in the chat. Masicho.
Great. Well, thank you so much, Caleb, for those remarks and information about the process in Canada. And as Caleb mentioned, we are talking with folks in Canada about having a separate special event that's focused particularly on US and Canada implementation efforts. So we'll look forward to planning that and talking about that more and letting folks know about that when we get it set up. Also, thank you so much, Professor Carpenter, for your very insightful remarks and tying together in such a fantastic way the three presentations of our presenters today and all the wonderful insights that you have there. So now we have a little bit of time for Q&A, about a little bit less than 15 minutes for Q&A. As Kevin mentioned at the beginning, with this format, you can raise your hand and we invite people to do that. We do ask that you keep your questions a bit short and concise, just in the interest of time. But if anyone would like to speak, let's see, I see one hand, and maybe if I can ask Kevin to help me with this as well, making sure that I see everyone who raises their hands. So we have someone who's raised her hand, Christine Benally. Would you like to unmute and ask your question?
Yeah. Yes, I'm logged in under Christine's account, but this is Anthony Peterson. And hello to you all. I'm coming in from Navajo Nation, specifically from the Four Corners, USA. This is the community of East Nas Pas, Arizona, in Apache County. My question would be, right now, we are working as a grassroots environmental activism organization to approach our Navajo Nation tribal government. We have a scheduled meeting on this May 5th at Window Rock to address Navajo oil and gas companies' oil fracking in our community, specifically to drill 60 wellheads throughout our community. And we're wanting to cite them as not having our community consensus involvement. And they are trying to do this, kind of mandating it to us, that when they had their public forum, they more or less saying that, presented to us saying that this is what you can expect. And then when we open it up to a question and answer Q&A, I tried to debate them, and our chapter president told us this is not open for debate. So right there, our voice was silenced in our community, and we felt like that's a social injustice to us. And so we hired an attorney and paid a retainer fee. And you know, we really feel like there's voter suppression and various different things that are going on at the higher legislative and judicial branches of our government. And we, the grassroots people of the community, have to say we are the voting quorum body that specifically have a 5-page petition signing that we do not want this oil and fracking process to happen in our community, in our unrepressed. We're really suffering in terms of severe drought that's impacting us, and then now this increased methane carbon footprint that they're going to put into our community is going to impact us twofold and increase our drought and use up all of our water resources. So we're really advocating and protesting against this, and you should probably be hearing more further developments on this in the newspaper and the national media. We were able to get acknowledgement from the Farmington Daily Times, and but our tribal government didn't make any social media outlets or efforts to acknowledge us. So we're kind of not being heard, and they took our item off of the agenda, and it's open up for discussion in the next council session on the May the 11th, when it goes before the Speaker of the House again. So I guess my question is that with all of this happening on our reservation, we were trying to find legal precedents, avenues or venues we could stand up to defend ourselves, inciting them. I was able to look into Apache County statutes and ordinance regulations and laws that are pertaining to, there's one that I found that had cited 2,640 feet, which is basically equivalent to a half mile, that they should not be able to frack within a residential or church or school area. And right now, the way that the Navajo Nation is interpreting their 10-year lease agreement is that they're basically giving them the green light and kind of like an open field day to go ahead and frack anywhere and everywhere they want. And that's just really repressive. And I don't know. I know I've been able to find a huge amount of case findings from the state of Colorado. Fortunately, they had instances where there were 70,000 gallons of wastewater spilled out from their fracking sites into their waterways. And then in addition to that, there's a number of health hazard case health impact assessments that have been done that people have been able to testify that they've been particularly impacted health-wise. There's the mortality of the low birth rate. The babies are being born at a lower birth weight that they're being conceived at, that they've been impacted by. There's numerous instances of asthma, emphysema, various different linkages to cancer, and a number of different things that are the PFAS chemical fracking fluids that have impacted not only the workers, but also the community at large in general. So I don't know how these laws are just now prevailing, and this is kind of at the cusp, the cutting edge of what's happening now in terms of state legislatures. And I think 8 states in the union have addressed various different legislations addressing this.
Yes, well,
so I think Indian tribal communities need to catch up. We need to do our part too to protect our sovereignty and not waiver our sovereignty rights.
Thank you, Mr. Anthony, or Anthony Sir, for those comments and for that information. And what I was thinking was that perhaps we could have a few more comments or questions from our viewers, and then we could open it up to our panelists for their responses. So if we have another person who would like to pose a question for one of our panelists, please raise your hand. Let me see. And again, Kevin, if you see someone raising their hand, please let me know.
Sue,
I see.
I'll ask a question. Yeah.
Sure.
So in Canada, there was a lot of failed efforts to get these kinds of laws passed at the federal level. And I was just wondering, I think there's going to be synergy between states and tribes, and I hope Canada and provinces. So Washington State, for example, with British Columbia, and the nations that are crossed by the medicine line. So I just was wondering if maybe the panelists could offer some comments on synergistic opportunities, such as you see them, because that's what catalyzed us. There was multiple aspects, facets, and groups who worked together to get this done, and it was a long process.
Great. And I see another hand, Gage Hansen, if you would like to take the floor.
Hello. I asked this question in text a little bit earlier, but the Universal Declaration of Human Rights has been implemented largely through the International Convention for Civil Political Rights and Economic, Social, and Cultural Rights. Do the presenters believe that we will need an international convention to implement the aspects of the Indigenous people's rights, or is the declaration itself sufficient?
I can take a stab at that just to start, if you'd like, Sue.
I'm sure, that sounds great. Thank you.
So yes, it is true that the ICCPR and that both treaties do implement many aspects of the Universal Declaration. I personally don't think that exercise here is the most effective use of time. and resources, and that's because, again, I think, as far, at least if you're what you're focused on is U.S. domestic law and achieving remedies. Even if it were a treaty, it's not self-executed under U.S. law, so you would have to domesticate it anyways. And so I also fear that the U.S. and a number of other countries, if it were a binding treaty, would want to limit some of the rights set forth in the declaration. They would take a different approach in the analysis of the declaration, and for that reason, it would most likely either be take a very long time, and then ultimately be significantly watered down from the provisions of the declaration. So I just don't see the benefit in that in this instance. I think that in my judgment, more energy should be spent in what NARF and the University of Colorado Law School are already doing, and others are doing, and what Caleb talked about is happening in Canada, which is to domesticate these provisions into the domestic law of each country, potentially in states, and to use as an advocacy tool for political purposes.
Thank you, Ambassador.
I'd just like to.
Go ahead.
Yeah, I'd just like to add what Keith mentioned as well, is that I think that I agree with his analysis to that question. I think the name of the game now in the United States is to domesticate the landmark UN standards into US law and policy. In the same way that right now it's unenforceable, but it remains to be implemented. Just like back in 1970, the President Nixon's Indian self-determination policy was just a policy. It was unenforceable. And it remained for Indian country to implement that across the nation. And it took 2 generations to really do that. And it's the same way here. We have to implement this declaration in our own country by similar kinds of advocacy. And it could be the work of a generation. The ball is in our court, the Native people, because Indigenous rights are never freely granted. They have to be advocated for, wrested away, and then vigilantly protected. And so nobody's going to do that for us. It's up to Indian country to do it. And it's up to our generation to do that through advocacy, similar to the way on all fronts, legislative, litigation, policy changes, and so forth. And it's up to our tribal leaders and our tribal attorneys and our tribal members to get human rights, learn about human rights, just like the First Nations in Canada, and reach out to the First Nations, Caleb and his colleagues, to show us the way, because they've learned how to do it, and they are pioneers, and they've accomplished very historic human rights achievements in their country that we here in the US could learn from. And so ball's in our court, and nobody's going to do it for us. It's up to us. It's up to the tribes to move forward and learn about human rights and become advocates, just like the First Nations up in Canada, to strengthen our legal rights for the next generation. And that's all I just wanted to add. But I think going to the international realm, it's would not be all that helpful. I think at this point, it's a question of advocacy, domestic advocacy, to take that landmark international instrument and work to implement it in our own country now. It's up to us.
Thank you. Thank you, President Echohawk. So now I'd like to call on Judge Greg Bigler from the Muskogee Creek Nation. And then I want to give Professor Riley a chance to speak as well and respond. So Judge Bigler, you have the floor.
Senator Gassada, thank you. And I think that President Echohawk answered some of the questions I was going to ask. Was that first, I really would like some input or thoughts from some of the panelists on the concrete steps we need to take. I know that Walter mentioned some of those, but it seems that we have placed some of our own people in the current administration in Washington, D.C. under the Biden administration. But it still seems like there's a great reluctance to move this declaration forward there. And I was curious what would be suggestions for for concrete actions to take or ways to raise that and move it forward. Secondly, it seems that there's a lack of education amongst our own Native peoples on this. And I was curious what suggestions, because if we don't have the lawyers talking to the elected officials about the declaration, those elected officials, tribal officials, are never going to raise it to whoever else is out there. So it seems that that's kind of a two-step process, is educating or figuring out how we can move it in DC, but also how we can get a increased support amongst our tribal level. And so if you have thoughts as to what processes need to occur in the short term and long term for that.
So Professor Riley or our other President Echohawk or Ambassador Harper, would you like to respond to that, please?
Sue, can you hear me okay? Yeah. I have a great answer for this question, but I did want to respond to one of the questions in the chat. I hope you all can hear me okay. But one of the questions in the chat was about unrecognized tribes and how the declaration might do that. I just want, this isn't something I've addressed directly in my work, but from perspective, the UN Declaration addresses the right of Indigenous peoples with self-determination as defined by themselves. It doesn't depend on a nation state that you are a people. In fact, the concept of definition in most places in the world is completely foreign. We're one of the few places that has a system like that, although of course the four settler nations all have kind of similar histories. But there are many Indigenous peoples in the world that have nothing to federal recognition, and many, of course, that aren't even acknowledged by the nation state in which they reside. So, from my own perspective, the declaration applies to Indigenous peoples writ large, and it doesn't depend on federal recognition. The practicalities, of course, are more complex than that, and we know that rights are not similar as between unrecognized tribes. In the example, one thing I'm happening in California is there's a greater emphasis on making sure that there's inclusionary practices with regard to unrecognized tribes, partially because of the history in California, ratified treaties and the massive fight that took place in this state. So with everything from, say, the University of California's new repatriation policy, which I helped write, to activities by the Native American Heritage, to new tuition scholarships go to Native students in the UC. All of those have features that are intended to make sure they're addressing the needs of recognized tribes as well as recognized. And I know it's just the tip of the iceberg, but I do think that there's an increasing acknowledged people, Indigenous peoples and non-peoples across the U.S. that the idea of federal recognition, colonial construct, and it's detrimental and devastating to Indigenous peoples, and it serves more to divide us than to empower us. So I think the declaration has the capacity to thanks.
Thank you, Professor Riley, for addressing that question. And I think for Judge Bigler's question and remarks and Caleb's as well from AFN, we will have to continue the discussion on those as we've come to the limit of our time. And I hope, Anthony, from the Navajo Nation, I hope you received some information more generally that was helpful in what you're looking at there. I did want to, again, thank all our speakers for sharing your valuable comments and insights today. You've given us a lot to think about and reflect on, and we look forward to utilizing this information as we move forward in our implementation efforts. I want to thank everyone for tuning in today, and also want to let you know about our final permanent forum site event, which is coming up this Thursday, May 5th, from 1 to 2:30 p.m. Eastern Time. And the topic of that is Language Rights Are Human Rights, Participating in the International Decade of Indigenous Languages. And we'll have as speakers Chief Ben Barnes from the Shawnee Nation, Delegate Kim Teehee, the Director of Government Relations for the Cherokee Nation, and Ophelia Zepeda, who is the Regents Professor of Linguistics for American Indian Studies at the University of Arizona. The registration link for that event is on our website at un-declaration.narf.org. Thank you again for joining us, and we hope to see some of you again on Thursday. Thank you very much.
Thanks, everyone. Take care. Thanks, Sue.